Privacy is a huge concern when it comes to IT security. As a citizen and as a consumer, it's your right that your personal identifiable information kept secure. And as an IT security professional, you need to understand and adhere to the laws that apply in your area. How strict they are in your area and how well consumers and citizens are protected depends on the legislation there. In the US, for instance, there's a lot of overlapping laws. It's really a big patchwork where laws have been added as we go along, but there's no overarching plan or vision, and in some areas there's no protection at all. The EU, on the other hand, has taken a different approach. They have an overarching vision. They have standards, and then the laws at the lower levels have to adhere to those. The EU laws are very protective of consumers' privacy and has a lot of safeguards in place on how we gather, use, and store data. And there are a lot of things that are normal business practice in the US that's illegal in Europe. In the US, they're more business-friendly and less consumer-friendly. And for the exam, there are certain US, European, and international laws you need to know and be familiar with. Let's cover the US ones first. One of the most well-known, at least within the US, is HIPAA. That's the Health Insurance Portability and Accountability Act. And it puts very strict privacy and security rules on how personal health information is handled. HIPAA has 3 basic rules: a privacy rule, a security rule, and a breach notification rule. And these rules mandate both administrative, physical, and technical safeguards to be in place. And to be HIPAA compliant, companies have to perform risk analysis. The US also has security breach notification laws, but it's not a federal mandate. It's handled individually by the states. And 40 of the 50 states have them. If you work in the US, you need to know the law for your state. The only state that doesn't have them is Alabama and South Dakota. They pretty much all have the same framework, where companies have to tell people if the personal identifiable information has been compromised. There's normally some sort of limit on how many people have to be compromised before they have to disclose. Most of the states also have an encryption clause. Basically means if the data was encrypted, they don't have to disclose that they were compromised. How strong of encryption varies from state to state, and on the exam it doesn't really matter. For the exam, just understand that if PII is exposed, they need to notify people, unless it's encrypted. If it is, they may not have to. Then obviously for your job, if you work in the US, know your state. Another important piece of legislation in the US is the Electronic Communication Privacy Act. It was made to protect electronic communication against warrantless wiretapping. But it was weakened a lot with the Patriot Act in 2001, and is to a large extent not very meaningful anymore. Which moves us into the Patriot Act. The Patriot Act was signed into law after the 9/11 attacks in 2001. It vastly expands the electronic monitoring capabilities of US law enforcement, and it also allows for search and seizures without immediate disclosure. The Computer Fraud and Abuse Act is what most cybercrimes is charged under. It was first made into law in the mid-80s, but has been expanded upon multiple times since then. GLBA, or the Grammley-Leeds-Bliley Act, applies to all financial institutions in the United States, and was enacted to protect the confidentiality and integrity of the consumer's financial data. As mentioned before, a lot of the US laws are reactionary laws. Something bad happens, they then put in a law to fix that one issue. The Sarbanes-Oxley Act of 2002 are similar to that. There was a lot of accounting scandals in the late 90s. As a result of that, they built mandatory compliance standards for the financial industry of publicly traded companies. This is one of the areas where gross negligence can actually lead to criminal penalties. The PCI DSS is not technically a law. It is, however, a standard you need to adhere to if you want to do business in the credit card industry. It is similar to what HIPAA is for healthcare, just for the payment card industry. The standards have a minimum requirements that the merchants have to meet, and if they don't, they're no longer able to issue credit cards or debit cards. If we look at the data protection laws in the European Union, we'll see they're a lot more pro-privacy aggressive. When an organization gathers data, they have to notify how it's used and that it's being gathered. There has to be the option to opt out of sharing with third parties, and there has to be the option where you can opt out of your most sensitive data being kept at all. It's also illegal to transport data out of the European Union unless the country you transport it to has the same privacy protection rules in place. They have to be as good or better. The US does not meet those standards. The EU-US Safe Harbor decision was a decision that the US met the EU standards and was made in the early 2000s, but in 2015 it was overturned, largely because of Facebook and Google's gathering of data. The OECD also have privacy guidelines. That's the Organization for Economic Cooperation and Development. These are international guidelines. Currently, about 30 nations are part of the OECD, including the US. And what they focus on is the protection of data and privacy as personal data passes over borders. These are guidelines, which is a very important distinction, which basically means these are not mandatory but suggestions. For the exam, I would know what they limit and what they don't, and what the idea behind them are. Limits what can be collected, that it's complete and current, that people should be informed that the data is collected, that the person the data is collected about needs to consent to it being used, or it has to be law enforcement asking for the data. Organizations collecting the data need to put reasonable safeguards in place to protect it. The organizations have to be open, divulging what they're going to use with the data. People need access to their own data, and with the option of changing it if it's inaccurate. And finally, the organization collecting the data are accountable for complying with all the other rules. It's very loose, some of it doesn't mean a lot, and it is guidelines. It's just suggestions. The Wassenaar Agreement is another example of an international arrangement. The agreement was initially focused on conventional arms, but has moved in to add dual-use goods and technologies. There's currently 41 countries that are participating. Cryptography is considered dual-use, so there can be both import and export restrictions on the algorithms. Iran, Iraq, China, and Russia, for instance, have restrictions on how good encryption, how strong encryption is allowed to be imported into their countries. While it might seem counterintuitive, it's a lot easier to spy on your citizens if they don't have very good encryption. That then means that companies and organizations that want to export goods to those countries, if they're exporting anything that has cryptography in it, needs to build it with weaker encryption. And finally, we also need to look at our own organization, our software, and what happens when we buy companies or split our company into smaller divisions. It's common for large organizations to have hundreds and hundreds of different third-party software running on their systems. This can either be on our internal servers and us sending our users to their servers. Regardless of the type, we need to ensure that the security is high enough for our standards. The attackers will look for and find the weakest link in our chain. It doesn't really matter if you have burglary-proof doors, windows, and an awesome alarm system if you get to lock the door. So we need that holistic security approach, and we need layered defense. And if we do buy hardware or software from a vendor, we want to have service level agreement in place. This could be where they promise us to have 99.9% uptime, a faulty hard drive is replaced within 4 hours, or something similar. The more aggressive the plan is, the more expensive it is. So here as well, we do a cost-benefit analysis, we find the right plan for our environment, and then pay for that. And of course they need to adhere to the standards we do. So if we handle financial transactions, they might have to be PCI DSS compliant. They have to go through the same audits we do, and they can present the audit to us to show that they are. As part of our service level agreement, we might also have a right to pen test or a right to audit to make sure they actually live up to our standards. This and much more would be defined in a service level agreement. And we also need to pay attention to what happens when we buy other companies. How do we ensure that their security posture is as good as ours? How do we integrate the two security postures? If they don't live up to our standards, we might not want to join the networks. Again, they would be the weakest link. We would go in and do our due diligence, and they will build a plan on how to fix their security posture, or just completely keep them separate. The same needs to be considered when we do a divestiture. That's when we split up the company. How do we ensure that the new companies are actually separate entities? How do we ensure that data doesn't cross between them? Who gets all the stuff? Who gets the data center, the servers? And how do we handle that in a secure manner? How do we ensure that company A doesn't have access to company B's data after we split up? Again, it's due care and due diligence. And understand for the exam, you are an IT security manager or a risk advisor. You're supposed to be the person that has all the answers, or at least know how to get them. And this is exactly why the CISSP is so broad. You need to understand all the concepts and how they tie in together. You need to advise senior management so they can make the right decisions.